and days later inside the jail, only based upon a strip search, did they then find that you had it in you. And when they tried to avoid having it fall out, and they had to do it again, that clearly might apply to the disorderly person. I got it. Had nothing to do with sneaking methamphetamine into the jail and keeping it for a couple of days in the jail, trying to hide it inside of you in the jail, failing to comply with the officers when they told you to squat and cough the first time. I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence. All right, our next case this morning is some people in the state of Michigan versus Jennifer Lee Williams. This is case number 25-14094FH. Appearances from counsel.
Joanne carried for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. As you may have already noted, she appears electronically from the Webster County Jail.
All right, thank you very much. Ms. Williams, are you able to see and hear the court this morning, ma'am?
Yes, sir.
Thank you. Ms. Williams, we are here today for an arraignment on a bench warrant. This court back on August 1st signed a bench warrant for your arrest. It was based upon an order that you had failed to enroll in drug testing as a term or condition of your probation. I'm sorry, of your bond or your pretrial release. Then additionally, we had a show cause for your failure to enroll in that program, and it looks like you failed to appear on that date, which was August 1st. Now, when someone fails to comply with the court order, it could be treated as a matter of contempt, for which a defendant could be sentenced up to 93 days and or $7,500 in fines and costs. The court recognizes before it also here in the back, Ms. Alex Matsky from the Western Missaukee Community Correction Program. So, Ms. Williams, we're not going to treat this as an issue of contempt. However, the court chooses to use it as a review of your pretrial release conditions, or in other words, your bond conditions. You have the right to challenge this allegation at a contested hearing and have the prosecutor prove the allegations, which could even be done right now if we so chose. At that, you'd hear some witness testimony. You could cross-examine that witness. You could also present witnesses' evidence or testimony if you chose to do so. And of course, you'll be represented by your defense attorney at that hearing. Again, the court must give you some due process. Now, if you're found to be in violation of your bond conditions, your bond conditions could be modified, continued, or bond could be revoked and you could be remanded into custody. Now that I've told you what the allegations are, what your rights are, and the possible consequences of your choices, I'm going to turn to Mr. Harrison. Mr. Harrison, how does your client wish to respond at this time, sir?
At this point, Your Honor, we would, in light of the fact that she's also set to be arraigned on new charges, at 1:30 today, we have no option, frankly, but to do something to contest the bond violation at this juncture as well.
Okay. So is there another allegation that she test positive?
She had a pipe.
Oh, she had allegedly had a meth. So that will also be dealt with at the hearing. Plus, I'm going to note that I'm concerned.
Right. Okay.
I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and presentation today via Zoom.
A similar concern was raised by jail staff this morning, so I feel more comfortable not proceeding today.
All right, thank you very much. Now, I did note that Ms. Williams appeared to make a comment. I did not hear that comment. I'm going to ignore it right now because she has counsel. Her counsel has spoken for her, and we will set it for a hearing. In the meantime, the court is going to deny the defendant bond and remand her into custody until the hearing. Thank you very much. We are adjourned.
Thank you.
All right.
I'm sorry, person at the jail, what is your name?
Jennifer,
Williams.
yes,
This is case number 253631 FY, the people of the state of Michigan versus Jennifer Lee Williams. We are here for an arraignment. Ms. Williams, did you have the opportunity to meet with somebody from the defender's office today?
yes, sir,
I have a complaint that alleges that on or about August 8th, 2025, in the city of Cadillac of Wexford County, in count number 1, it is alleged that you did commit the offense of possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it is alleged that you did commit the offense of police officer assaulting, resisting, or obstructing, in particular Sergeant Zach Hicks of the Cadillac City Police Department. That is a 2-year felony punishable by up to 2 years in prison and or $2,000, and consecutive sentencing may be imposed if it happened in place of confinement. In count number 3, it is alleged that you are a disorderly person who is found jostling or roughly crowding people in a public place. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In count number 1 and count number 2, the prosecution has also elected to charge you as a habitual second offender. That means that you have at least one prior felony or attempted felony in your past. That makes the 10-year felony and the 2-year felony punishable by 1.5 times that amount. Do you understand those charges and potential penalties?
yes,
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, and historically, I show a jostling in 2019, domestic violence in 20, in 24, a larceny less than 200, in 24, an attempted resist and obstruct. There was a 4A case back in 17. In 06, there was an MIP of alcohol, 22, an operating while visibly impaired, and 25, a trespass. It's my understanding that she has a bond violation out of the circuit court for I think it was a drug charge and possession of contraband, if I remember correctly. My probable cause affidavit that I read today indicates that she was maybe in absconder status in the circuit court. And I know there was a bond arraignment or bench warrant violation arraignment today in which was set for a contested hearing, if I remember correctly. Probable cause affidavit also indicated that looks like there was an attempt to apprehend her by the bounty hunters, so to speak, looking for her. Any comment regarding bond defender's office?
I apologize. I wanted to make the court aware that the circuit court, according to I was informed by Mr. Tubb, the circuit court did not accept any plea from her today because she appeared to be under the influence of something to them. I spoke with her about an hour ago, and that didn't strike me to be the case. So I just wanted to make that statement.
I will state for the record, I did watch her arraignment this morning via the live stream because I was curious what was going to happen. And it did appear that, to me, it looked like she may have been nodding off at times, but I'm not sure about that. So I can understand where the court was coming from with that.
Okay.
But
I will just say I would be comfortable with the state of mind that she was in at least an hour ago, and assuming it's remained the same with proceeding as usual. I would like to say that the incident, at least where she was picked up here, I don't know, I feel as if mentioning it because I found it sort of uniquely like an awful way to get arrested, was her baby's father more or less tricked her into thinking that she was going to see the child for the first time in 3 years, and then she got arrested. So I thought that kind of sucked. Not that that impacts bond in any way.
is that from when they were trying to apprehend her for her bond violation?
I believe so.
The bondsmen were trying to apprehend her?
Yes. That being said, she does have a support network that's growing here in the city. She has a partner who she would like to stay with. And then she also has I wouldn't say a job lined up, but work lined up at a house that she can stay in. So that would also take care of housing. She wasn't able to give me the address for that, but it did sound credible to me. So thank you.
Ms. Lawrence?
Thank you, Your Honor. I don't think I need to go into too much detail, as the court stated they read the affidavit on this case. I think it's pretty clear the defendant cannot be successful on bond, since she is on bond in circuit court for another possession of meth. And she picked up this new possession of meth while on bond, and also her failure to appear in circuit court as well.
All right, the court finds that Ms. Williams presents as a flight risk in that she was absconding from circuit court bond, and by the praxis, it looks like for over a month, and that she had failed to enroll. I assume that's in testing, at least based on the findings in the probable cause affidavit that I had to review in order to find probable cause for the charges today. It does appear that she was trying to be apprehended by the bondsman's bounty hunters, and it was not going so well for Ms. Williams. So I do find that she is a flight risk. I also find that she's a threat. I am going to order a $50,000 cash or surety bond, since the $25,000 didn't keep her coming back to court or following the bond conditions. Ms. Williams, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. On the situation that you are released from jail, I'm going to order that you be placed on a GPS tether for location purposes only. Ms. Ejomera, anything else?
No, Your Honor.
All right, we're adjourned. Thank you, jail.
Thank you, Your Honor. Have a nice day.
You too.
Appearances, please.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. I apologize for my rising.
That's all right.
My computer's being extremely uncooperative this morning. I don't know why.
Ms. Williams is now brought in. She is currently in pretrial custody. Have a seat. Also single conviction for possession of methamphetamine, and file ending in 1-7 has 2 counts. Each are misdemeanors. The first is a disorderly person, and the second is attempt assault, resist, obstruct a police officer.
The recommendation could be read to say time served is sufficient with a period of probation to follow. Now, I back that up, and the only reason I'm getting into the semantics of it is that it doesn't come right out and say that in the report, but that's definitely what I would propose the court to do here. This is the culmination, these 2 events that are complained of and discussed in the PSI. There's the culmination of, how should we say, a particularly fraught period in the life of Jenny Williams. And the first thing that she said to me when she came back to jail on the second charge was, "I'm sorry." And I said, why are you apologizing to me? And she said, I'm not, I'm apologizing to myself. That was really, I really need to get a handle on what's going on with my life. She needs drug rehabilitation. She has made efforts to try and get it. She's talked in terms of completely changing her outlook and attitude, and perspective. I think for a long time, and it was easy for her to fall into this, she played the victim, that everything was happening to her instead of everything was happening and she was a part of it. I would encourage the court to follow the recommendation, impose a period of probation, and no further jail time.
Thank you.
Thank you, Your Honor. Ms. Williams bonded out I think on July 3rd and failed to enroll in drug testing. She spent, I would guess, a week and a few days in jail on that initial payment. Testing, absconded for a month. And then when bond agents and later police caught up with her, she had a methamphetamine pipe on her. I think period of probation for 3 years and a 12-month jail sentence is appropriate given her behavior on bond and these guidelines. I'd ask the court to impose that. Thank you.
Ms. Williams, you have the right to make a statement if you choose to do so. Is there anything you wish to say today?
Yes. Just thank you, Judge. Probation. I'm really excited about that. I know a lot of people probably aren't excited about probation, but I personally know that it is helpful. It's basically like having a sponsor, a committed sponsor for myself for, you know, the next couple of years. And it'll be helpful to get me in a positive routine and staying in it. So I'm excited about that. I want to apologize for being here. I do feel like an idiot because of the circumstances and everything. I did have the bag in jail. I was never asked if I had anything that I shouldn't have, so I kind of panicked. I didn't know what to do, and I know that sounds so stupid, but I didn't want to flush it, and I didn't know how to come out and say, hey, I have this and I don't know what to do. But I didn't want to flush it because I didn't want to be like, oh, I'm getting rid of evidence. You know what I mean? So it's kind of like I froze. I was waiting for a moment to happen to where I could be like, hey, I have this and I know I shouldn't have it. Can you please take it from me or whatever? But I was scared. I was scared and I froze and deer in headlights. Like I didn't know what to do. Did I have intentions of ever giving it to anybody else? No. I had thought, okay, I could try and get rid of it and flush it or swallow it or whatever, but I didn't want to do that. That's why I still had it on me for 2 days because I just didn't know what to do with it. I wasn't going to use it and I wasn't going to get rid of it. I just didn't know how to present it in a way that didn't end in some kind of a struggle because I was like in fear that I was going to be tackled to the ground or something stupid, you know. I'm going to be tackled for having something I shouldn't have, and I was in fear. Now I know that'll never happen again in the future, but if I can at least have a story to tell others, not to be afraid to say if they have something they shouldn't have. I just wish I would have been asked because I'm one of the most honest people you'll ever meet. I was hoping to meet you in other circumstances. I do appreciate you as a judge, Judge Elmore. I think you are a great judge. And
Somebody said that 2 weeks ago, but then when I started to give my sentences.
I know I'm probably gonna cry, and so that sucks. But you know what? I got myself here. So I mean, whatever happens, and I'm a firm believer in fate. Whatever happens is meant to be. Thank you.
Thank you, ma'am. You may be seated. Normally, it's somewhere mentioned in the evaluation of plan. At least I don't think I saw it. You absconded for bond. So what I heard was, Judge, I went to a rehab program just last year, and I meant to continue with treatment, but I didn't. Judge, I knew I should have gone into the homeless shelter, but I didn't. Judge, I knew I should have complied with the bond conditions that you gave me for testing and monitoring, but I didn't. So a lot of it was but I didn't. I knew I had the stuff on me, or better put, inside of me. And I should have gotten rid of it. I should have said something, but I didn't. And when I look at the description of the offense, you didn't mention it, but Mr. Harrison did. Underneath your description, when it asks, what did you do? I had a bag of methamphetamine on me. I didn't realize I had it because I never have any. Other people usually get me high. Well, there was the meth pipe found with the residue during the arrest. And days later inside the jail, only based upon a strip search, did they then find that you had it in you. And when they tried to get you to produce it, you did what you could to avoid having it fall out, and they had to do it again. So here a lot of, I know, I should have known, I could have, and every single time it was responded with, but I didn't. And this, I didn't realize I had the baggie on me. Now here's something Mr. Harrison picked up on. You didn't mention it, but kind of picked up on that you would blame other people. No, in your description of the offense to why did you do it, and this might have to deal with the events over by G&D. I got upset and riled up when I got arrested because my son's father and the bounty hunters tricked me. That clearly might apply to the sort of person. I got it. Had nothing to do with sneaking methamphetamine into the jail and keeping it for a couple of days in the jail, trying to hide it inside of you in the jail, failing to comply with the officers when they told you to squat and cough the first time. That was your choice. While you got out on bond here, you got picked up for committing more offenses. So you absconded on my bond when we gave you a chance, our bonds when we gave you a chance. You only got picked up because you were committing more crime. You've got a couple probation violations in the past. You've got a couple cases that they occur back to back almost with very short periods of time. You're on a track of going nowhere, and I want you to help figure this out. So now I've got to figure out what's best to do. Mr. Potter, what do you think there about programming possibilities? I want to give her a change. She's got to get a diploma. She's got to get this some treatment, and I've got to do something different than anyone else has done with her yet. What's your thoughts?
30 days is probably the most we can get for residential treatment right now, Your Honor, released from jail. And we could get her enrolled in GED, maybe an online program or in person. With that, Your Honor, driver's license help actually would be more through the prison.
Yeah, that's another thing. You probably need all that help. So here's what I'm going to do. Court sentences the defendant to for file ending in 9/4, $68 state minimum fee, $130 crime victims' right fund fee. Court sentences the defendant to a period of 13 to 120 months and gives the defendant 83 days of credit. The court will approve boot camp if you choose to apply. Oh, if you get there and this is what you want to do and you want to get out earlier and you want to get some treatment and you do the boot camp, I will approve it. And I'll deduct those kinds of numbers that I mentioned earlier. So you'll get to do the program and hopefully you'll get out in less time than if you were in the jail, and you should come out further ahead than you would be if you were in the jail. Thank you. Now, I'm hoping Miss Williams, you do exactly what I've proposed because it will help you in the best way. And you'll note that there's a decision here. Remember how I said earlier, you kept saying I could have did this, but I didn't? But apply for boot camp. That's up to you. Ms. Williams, remember, the next step starts with you making a choice. Don't come back and say, well, I didn't. Okay. Good luck. We're adjourned.
Thank you.
Yes, ma'am.